They're invested in the lives of their fellow Georgians, and the Walters are really, to know them is to love them. And I want to thank you for that. But I also want to thank every member of this body as well, from both parties that have loved on the Walters family. You've really showed your humanity, and I'm grateful for that. Senate Bill 79 also complements the General Assembly's ongoing efforts to combat and treat opioid abuse in Georgia, including through efforts to make naloxone widely available in schools and other public buildings. Fentanyl is a synthetic opioid typically used to treat patients with chronic severe pain or severe pain following surgery. Fentanyl is a Schedule II controlled substance that is similar to morphine, but it's about 100 times more potent. Under the supervision of a licensed medical professional, fentanyl has a legitimate medical use. Patients prescribed fentanyl should be monitored for potential misuse or abuse. But some facts about fentanyl: 2 milligrams of fentanyl can be lethal, depending on a person's body size, tolerance, and past usage. DEA analysis has found counterfeit pills ranging from 0.02 to 5.1 milligrams, more than twice the lethal dose of a fentanyl per tablet. 42% of all pills tested for fentanyl contained at least 2 milligrams of fentanyl, considered a potentially lethal dose. Drug trafficking organizations typically distribute fentanyl by the kilogram. 1 kilogram of fentanyl has the potential to kill 500,000 people. According to the CDC, synthetic opioids like fentanyl are the primary driver of overdose deaths in the United States. In 2021, overdose deaths involving opioids rose 38.1%, and overdose deaths involving synthetic opioids, primarily illicitly manufactured fentanyl, rose 55.6%, and appeared to have been the primary driver of the increase in total drug overdose deaths. Fentanyl, if other illegal drugs are a BB gun, fentanyl is a nuclear bomb. I say that to say, if you look at the numbers, the people that were killed combined at the bombing of Nagasaki and Hiroshima roughly equals the amount of Americans that die every year from fentanyl. This was provided to me by Mr. Gus. This is 4 grams of fentanyl. 4 grams. I want y'all to look at this. 4 grams. This will kill 2,000 people. 2,000 people. This packet right here, this is cellulose, but if this was fentanyl, it would kill every senator in this chamber 35 times over. Think about that. I have 4 packets here. That would kill 8,000 people. This is 1 gram of Splenda. 1 gram. 1 gram of fentanyl will kill 500 people. 500 people. We have 537 cities in the state of Georgia, and only 6 of the cities in the state of Georgia have a greater population than the amount of Americans that die every year from fentanyl. Part 1 of this bill removes fentanyl from the current statutes relating to possessing, selling, distributing, manufacturing, and trafficking opioids, and creates a separate schedule of offenses specific to fentanyl. Again, specific to fentanyl, because fentanyl is unlike any other drug that our nation has ever seen. Specifically for the purchase, possession, manufacture, distribution, and sale of fentanyl, the bill would change the penalties as follows. Under current law, if the aggregate weight, including any mixture, is less than 1 gram of a solid substance, less than 1 milliliter of a liquid substance, or if the substance is placed onto a secondary medium with a combined weight of less than 1 gram, by imprisonment for not less than 1 nor more than 3 years. Current law for possession starts at 1 gram. Senate Bill 79 lowers that to 250 milligrams. Now keep in mind, 250 milligrams will kill 120 people. The next tier, under past law has been 1 gram to 4 grams, was 1 to 8 years. Senate Bill 79 changes it from 250 milligrams to 4 grams, and the term is 1 to 10 years. Currently, like other opioids, a person must possess at least 4 grams of fentanyl to commit the offense of trafficking. This bill maintains that threshold, but establishes significantly higher mandatory minimum sentences and fines for trafficking in higher amounts. This bill does not add in mandatory minimums. Mandatory minimums are already in place in law for trafficking. If the quantity of the substance is more than 4 grams but less than 8 grams, the person receives a mandatory minimum sentence of 10 years in prison and a fine of $75,000. If the quantity of the substance is at least 8 grams but less than 14 grams, the person receives a mandatory minimum sentence of 15 years in prison and a fine of $150,000. If the quantity of the substance is 14 grams or more, but less than 28 grams, the person receives a mandatory minimum sentence of 25 years and a fine of $250,000. And lastly, if the quantity of the substance is 28 grams or more, the person receives a mandatory minimum sentence of 35 years and a fine of $750,000. Part 2 of the bill updates a number of cross-references throughout the official code of Georgia to the code sections created or amended by this bill and provides conforming changes with respect to offense terminology. Part 3 establishes that July the 1st, 2025 is the effective date of the bill and provides that it will apply to criminal offenses committed on or after that date. I want to show you a picture. This is a picture of a penny. That's the amount of fentanyl that it would take to kill one person. That $5,000 scale that my local pharmacist has, this is not enough to even measure on his scale. Think about that. My work with Austin's Law, I've had so many people across, mothers and fathers across our state. I had somebody in the chamber today tell me that their nephew died from fentanyl overdose 5 years ago. Just last night, I had a call that a doctor in South Georgia, the mother, she walked in the bedroom yesterday morning and found her 18-year-old son dead in the bed from fentanyl. It is an epidemic. It is an epidemic that's ravaging across this country. And I've said it before, and I will say it again. It knows no socioeconomic status. It knows no race. It knows no religious affiliation. Any of the ways that as society we separate ourselves, fentanyl affects them all. Anytime I get in front of kids now, I'm that dad. I'm that dad that's the Debbie Downer that gets and tells them, listen, whatever you do, do not take anything that everybody gives you. From my work with this bill and the heartache that I've seen from so many of our friends across the state who have lost their loved ones, especially their children. We named this bill the FEAR Act. Fentanyl has shot fear into the hearts of parents all over this country. By strengthening the penalties of those that are spreading this poison in our streets, it is my hope that we can turn the tables and inject a little more fear in the people that are taking the lives of our young ones, our loved ones, our children. I think this bill's fighting back against the fentanyl epidemic. I appreciate the Lieutenant Governor for allowing me to carry it on his behalf, and I urge your favorable consideration. With that, Mr. President, I'd be glad to take any questions.
You have no questions, Senator.
Thank you, Mr. President. I urge your favorable consideration of this bill, and thank you for your attendance.
Thank you, Senator. Appreciate all your hard work on this. Recognize the senator from the 14th.
Thank you, Mr. President. I rise for the difficult task of urging you to vote no on this bill in its current form. And I want to give you just a couple minutes of explanation why, because I don't want to vote no with no explanation. For context, I voted for the final product of Austin's Law last year. The reason is because the bill went to the House It got changed a little bit and it came back in some very important ways. Remember, last term, Austin's Law was an involuntary manslaughter charge, an aggravated charge, that had to do with fentanyl specifically. Now, the final product of the bill did not have an intent or knowledge element. What I mean by that is you can still be guilty of the aggravated involuntary manslaughter even if you don't know that there's fentanyl involved in the substance. But what we did do in the House, and for final passage here, is we limited the aggravated involuntary manslaughter charge to cases where somebody is either selling or manufacturing. And that's an important distinction, the production side of this versus just the possession side of having drugs. The reason it's important to target the production side is because if you target the possession side, which this bill does, then you are recreating the mistakes of the last few decades of American war on drugs policy. And I want to say, with respect to the LG's office, my good friend from the 8th, and the Walters family, who I know has to go through a lot even just to be here, and I want to show the utmost respect for their loss and their pain, and the loss and the pain of so many families who have gone through this. We have to be able to draw a line that reflects sensible public policy. So what the war on drugs did, starting under Nixon and continuing under Reagan, is it criminalized mere possession of drugs, mandatory minimums, hundreds of billions of dollars dedicated to failed initiatives that locked people up for nonviolent offenses for long periods of time. Every policy expert on this area agrees that the war on drugs, the way that it worked, was a failure to criminalize possession alone. When you criminalize possession, you are criminalizing addiction. Because people who have addiction, which is a mental health problem, it is a disease, they will be in possession of drugs. Whether they're selling them or giving them to anybody else, they have to have them in order to use them. So when you criminalize just possession, you are sweeping into the ambit of your regulation, the criminalization of it, people who have a chemical mental health problem, a disease. When those people go to prison, they deal with their addiction problem in prison, which is often untreated, in addition to all the problems that a place like Georgia Department of Corrections currently has, as we know from the Department of Justice, and from the hundreds of millions of dollars in supplemental spending we just voted on today to address basic prison conditions that need to be better. Prison is not an answer to addiction. It is not an answer to mental health crisis. And when we tried it for decades, it just didn't work. In fact, it made the problem worse. Let me tell you a personal story really quickly. I got involved during my time in the legislature with the family of a young man who was sent to prison because he and a young woman who unfortunately died shared drugs. They did not sell them to each other. They were just people who both had a problem. They both took drugs, and one of them very tragically died. The young man went to prison, and I was in communication with his family, where he was wasting away. He was disassociating. He wasn't recognizable as the same person. Family was going to meet with him. It was hard enough to get time with him. And they were so terribly sorry about what happened to the young woman. Of course they were. I mean, can you even imagine being a parent on either side of this equation, to lose somebody or to know that your child participated in a situation where somebody was lost? Tragic. But they almost lost their son, and if it weren't for some action by the parole board, he might have died in prison. Now, the difficult thing about this, both politically and personally, emotionally, is the victim was objecting. Victims' rights in Georgia, you have the right to object to somebody's early release, and the family of the young woman consistently objected to his early release. And we can all understand why, for the same reasons we're having this conversation. Because when you suffer a loss so senseless and tragic, you want there to be an explanation. You want somebody to be held accountable. And if there's nobody within reach, if you can't reach the Mexican cartels, if you can't reach the people who sold those drugs, then of course some of that sentiment gets placed on the person who shared the drugs, who possessed them jointly with the person who died. That guy's life, the young man who got released from prison, his life was probably saved by a little bit of grace, notwithstanding that he fell on the wrong side of all of our drug laws. I want to go to the bill really quickly. SB 79 on page 2, starting line 22, you have the simple possession offense. And the enhanced penalties don't distinguish like we did last year with selling and manufacturing. It just says if you violate subsection C, if you possess the substance, you're guilty of a felony, and these are the penalties, including mandatory minimums. Now, I want to be very clear. The senator from the 8th is exactly right about pure fentanyl and the effects that pure fentanyl has. Pure fentanyl, unadulterated, is a nuclear bomb. Everything he said about its ability to kill, the picture of the penny, the fact that it's not readable by the scale, all true. But everything the senator from the 8th said would be applicable only if the bill only criminalized weights according to pure fentanyl. That's not what the bill does. The bill as currently written says any mixture that contains any fentanyl. So you could have a baggie with 4 grams. There's about a teaspoon, by the way. Or, I had to Google this. I didn't know this personally. But, an 8-ball, it's like 3.5 grams. It's like a teaspoon. That's a normal amount of cocaine that somebody might buy. That mixture could be 99.99999% ordinary cocaine and just that tiny amount of fentanyl, but you'd be charged on the weight of the mixture. You would not be charged on the weight of the fentanyl. I want to be very clear. So the 4-gram cutoff, by the way, puts us into trafficking. So now you look at the next part of the bill, page 3, line 58. Did you know that if you have over 4 grams in Georgia, simple possession, this is not trying to sell it, not trying to distribute it, you just possess it. 4 grams. That's a trafficking offense in Georgia with enhanced penalties, 4 and up. So again, if you have 4 or up of one of these substances, regular cocaine, but it's got that tiny microscopic amount of fentanyl, if it tests positive, you are now liable under the trafficking provisions of this bill. And again, I can't stress enough, simple possession of that amount is what triggers the enhanced penalties under this bill. So colleagues, just like I said last term, it is the last thing I want to do on a Wednesday is come up here and speak against a bill that has a name attached to it, a person who is cherished by the family in the room, who stands on behalf of all families and lost loved ones who are affected by this crisis. But as we learn the painful lessons from the trillions of dollars, really, in the war on drugs, we need to treat addiction. We need mental health resources. We need to meet people where they are. And I'm not trying to be offensive when I say this, but the very people that this bill is designed to protect could be charged under this bill. A person who dies because of a drug that has fentanyl in it, let's assume they were arrested before they actually took the drug and died, they could be held liable under this bill for possession, and then maybe their life would be spared for the moment, but they would go to the Georgia Department of Corrections, where their addiction problems would continue, where they would deal with other crises, and the pendulum would be swinging back towards the failed policies of the 70s and 80s and beyond. Colleagues, I know that for you to vote a certain way on a bill requires, number one, that you agree with what I'm saying, but also, number two, that it be a politically tenable position, that you're not afraid to defend publicly. I get that. But I am unafraid, at least today, to stand here and tell you that criminalizing simple possession, criminalizing addiction is not good public policy. The House saved us from a worse version of this bill last year, and I supported the final version. It is my sincere prayer that the House can do something to this bill to send it back to where we are not recreating the mistakes of the last 50 to 60 years. I love and respect you, Senator from the 8th, and I'm grateful for your attention to this issue, grateful for your work. I'll yield for any questions.
You do have a couple questions, Senator. Senator from the 37th.
Does Jim yield?
I do.
You make a pretty persuasive point with respect to maybe some unintended consequences. Do you have specific language to fix what you're talking about that can tie to the quantity of fentanyl that you're referring to? Do you have a fix? Do you have a recommended amendment, a friendly amendment to offer to the senator from the 8th or not?
Wasn't prepared to do an amendment today, and I think this discussion would be much better had in a more efficient, comprehensive way in the House at this point. What I would say is, obviously, current law, as the Senator from the 8th pointed out, contemplates both mandatory minimums and criminalization of simple possession. Clearly, I would like the law to move in a direction that doesn't criminalize simple possession at all. I think it's pretty harsh that we elevate to a trafficking penalty, just based on simple possession with no intent to distribute, that sort of thing. As far as an amendment to make this better today, let's do something like what we did for the aggravated involuntary manslaughter charge last year. Let's limit these aggravated penalties to production, manufacturing, selling, or even intent to distribute. Because, by the way, the aggravated involuntary manslaughter charge, we originally had a sharing element in it, which you could imagine people who are addicted sharing drugs. I might even be, and again, not that anybody cares what my vote's going to be, but I might be open personally to an intent to distribute element sort of cleaning this up. But I think at the very least what we don't want to do is allow this type of enhanced penalty for people who simply possess with nothing more than that.
Does the senator further yield?
I do.
So if a senator were of the same mind as the senator from the 8th that wants to criminalize possession in the way he has, but wants to get the quantity correct, such that trace amounts, that's a trace amount within a larger substance is not unintended, kind of get you there. It sounds like you don't have a proposed amendment that could fix that, and you're suggesting that it's a House fix. If that's a technical fix, that the senator might be friendly to.
That may be right. I mean, one thing that I got to acknowledge for the senator from the 8th is because such tiny trace amounts can be deadly and because they're hard to measure, it's actually quite difficult to use a weight-based measurement of the pure fentanyl itself to try to limit it, right? So if it were a little less potent, then maybe you could use a weight, think if the substance has this much of the pure fentanyl, et cetera. But my thought would be one way that we just avoid that is you just, the simple possession by itself. I mean, again, intent to distribute, not too hard to establish if you've got certain quantities, I think. But you put people in a position where, again, and I don't mean to bear too hard on this point, but a person who this bill is designed to protect is a potential criminal defendant under this bill. I mean, if you just have something, whether you know it or not, if somebody buys street drugs and they don't know that there's trace amounts of fentanyl in it, which way is it going to go? It could be just the vicissitudes of fate. You either die because you take the drug or you get criminally charged because you're found to be in possession of it. But I think it just creates a really tough continuation of the war on drugs.
Thank you.
Yeah.
Recognize the senator from the 41st.
Thank you, Mr. President. And thank you for, Senator, do you yield?
I do.
Yeah, I want to begin, isn't it true that I'm grateful to the Senator for the 8th for all of his work on this work to try to make Georgians safer?
We all are, and we share the same goal of eliminating fentanyl completely from the communities that we live in.
Yeah. Do you further yield?
I do.
Isn't it also true that many families who have been impacted by fentanyl and overdose situations have sometimes opined and said, I would rather my loved one be in prison and alive than have OD'd and died. And so there's this kind of sense that prison is a safer or better place for a loved one who's dealing with this type of addiction. However, isn't it true that just in January alone, 2 people incarcerated in Department of Corrections died of overdoses in the prison itself?
That is correct. It's an ongoing crisis that has been going on for years that we've tried to call attention to. But let's just also say, I mean, we're the legislative body for the state of Georgia, and I hope that we don't feel like we're limited to those 2 options, that somebody either dies or they're in prison with an addiction problem. I mean, the whole point of the conversation I'm trying to have today from the well is, can we not imagine a different way of approaching this problem that has to do with treatment and health care and resolving the core issues involved, as opposed to searching for at best very imperfect tool to try to respond to this problem.
Thank you.
If there are no further questions, Mr. President,
You have no further questions.
I'll yield the well. Thank you.
Senator's yielded. Does any other senator wish to speak for or against the measure? Hearing none, senator from the 8th can close the debate.
Thank you, Mr. President. Just want to clear one thing up, that there are currently no mandatory minimums with possession. This bill does not create mandatory minimums with possession. There are mandatory minimums under current law with trafficking. This bill does maintain that for the 4 grams. But it's interesting you're talking about fentanyl and say, if it's a mixture of it. This is 4 grams. If it was 98% some other substance, it'd still kill 4 people. We have to have our laws address just how deadly fentanyl is. Perhaps if we address it and we strengthen our penalties and we make the punishment be reflective of just how fatal this stuff is. Perhaps these people that are selling illegal drugs across our communities will find something else to sell besides fentanyl. Because let's be honest with ourselves, 4 grams of cocaine is not going to kill 2,000 people. Even when you go back to the possession, we've got the 250 milligrams of possession. 250 milligrams will kill 120 people. Say it's 99% some other inert ingredient. That would still kill somebody. Literally. You can't even hardly see it. So I would just say, I would urge your favorable consideration. I do want for everyone to understand that there are no mandatory minimums for the simple charge of possession. It can be a suspended sentence. You could get a year probation. There are no mandatory minimums. In the trafficking portion of it, the mandatory minimums that are already in law, we're maintaining that, and we're also not changing the amount. But we are changing the penalty. It is going to be a stiffer penalty, and we're trying to make the penalties be reflective of what's going on in our communities and how fentanyl is so much more deadlier than any drug this nation or this world has ever seen. And with that, Mr. President, I'll yield the well.
Thank you, Senator. Is there objection to the previous question being ordered? Without objection, the previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill. All those in favor of the bill vote yea. Opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 50 and the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed. Recognize Senator from the 31st. For what purpose do you rise?
Mr. President, I ask unanimous consent to excuse the senator for the 30th for business inside the Capitol.
Without objection, Senator from the 30th is excused. Recognize Senator from the 41st. For what purpose do you rise?
Thank you, Mr. President. I ask for unanimous consent to excuse the senator from the 22nd.
Without objection, the senator from 22nd is excused. All right, last bill of the day, Senate Bill 123. 123. Secretary, read the caption.
Senate Bill 123 by Senator Kennedy of the 18th and others, the bill to be entitled an act to amend Subpart 2 of Part 1 of Article 16 of Chapter 2 of Title 20 relative to compulsory attendance so as to update and revise provisions of the state's compulsory school attendance laws to provide that no student shall be expelled by a public school solely to absenteeism, to provide for reporting requirements, to amend Code Section 20-4-141 of the Official Code of Georgia Annotated related to establishment of pilot program, awarding of high school diploma to successful participants, skills and knowledge, eligibility for participation and regulation so as to make conforming changes, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Education and Youth recommends that this bill do pass. Respectfully submitted, Senator Hickman, Chairman. Mr. President, that completes the order.
Senator from the 4th, for what purpose? Oh, we want to speak to the bill. Recognize Senator from the 18th.
Thank you, Mr. President. Good afternoon, colleagues. Thanks for hanging with us. Last bill of the day. You know, we often come up here and say, here's a bill for the little children, and let's help the children of our state. But this really is one of those bills that does just that. It's a feel-good bill in the sense of we're really looking at trying to fix a problem that children have of not attending schools. So last summer I was traveling like you guys often do, and was traveling to a seminar, was out of state, picked up a newspaper, and there was an article about the absenteeism problem in that state. So read the newspaper on the plane ride back, came back and asked my staff, and I said, what's the status of absenteeism here in Georgia? And to come to find out, the numbers were shocking, and they are shocking. Absenteeism is defined as basically missing children that are chronically absent, that are missing 10% or more of the school days of a school year, which basically equates to about 18 days. Well, you may wonder, well, how many children are affected by this? How many children are chronically absent? And the number is shocking. 360,000 school kids in our public school systems last year were chronically absent. So the number is substantial. So we started looking at this. I want to thank my policy advisor, Kaylee Bell, who started digging into this issue. She went to seminars. She talked to various constituent groups to figure out what could be the possible approach to this, understanding that it's probably something not very simply or just easily fixed. But I bring to you Senate Bill 123, and it's the product of a lot of her work and others that had input into this. The numbers of the chronically absent students now, well, let me tell you what they were before COVID, hovered around 9.5%. As you would have expected, they spiked during COVID at about 25 or 26%. They have come down, but they're still 21.3%. Last year, 21.3% of our children were chronically absent for the school year last year. So the question is, what do we do about it? Well, we need to do several things, and that's what the bill outlines, and I want to walk those through with you in just a minute. But before I do, I want to tell you that whether it's fully funding our public school systems or increasing teacher pay or leveraging state resources to help improve our Georgia literacy rates, which I commend our senator from the 4th, I quite frankly took inspiration from our dear friend, the senator from the 4th, that recognized a problem early on that was not something that was being talked about. And because of his good efforts and the fact that there's a focus on literacy issues and the challenges of our state, we now have identified a problem and have a solution in play. I hope that we will do the same thing with absenteeism and thinking about how do we fix it. So, I will tell you that you're going to hear something about you may know about or may not called a school climate committee. I didn't know we had such a thing. That goes back to the statutes that were passed by this legislature in 2005. We're updating the school climate committee approach to include now the problem of absenteeism. And we are also creating something called an attendance review team. Let me walk you quickly through the sections of the bill, not each one. A couple of things involving, you'll see a changing in the wording from mandatory attendance to compulsory attendance. That just modernizes the use of the word. You'll find that we are including in the definition of parent or guardian, not just those two terms, but we're updating it to include parent, legal guardian, custodian, or any other individual who holds legal authority to act on behalf of the child. You'll see that we have stricken a provision that says, under the law right now, where students can actually be expelled for not attending. Now, that's a little bit counterintuitive, isn't it? Of course it is. So we've stricken that provision so that children cannot be expelled from school just based on absences. We have retained provisions that identify when appropriately recognized excuses, when the child either has medical issues, family issues, whatever is within the statute, then those are not counted against them as well. In our conversations and work on this over the summertime, we solicited feedback from the Department of Education, from individual and other school administrators, from Superior Court judges, and others about the school climate committees. Under current law, each county is supposed to have a school climate committee, but these committees are assembled by the chief judge of each county. That's currently in the model that we have. And the purpose of the climate committee is to bring officials together from various lenses of the community to deal with this issue. But what we're adding to their traditional duties is chronic absenteeism. You should have on your desk a handout that looks like this. And you'll see under school climate committees, which was formed in 2005, we're really there to focus on morale and safety. We're adding chronic absenteeism to the work of the school climate committee. It's important to note that the membership of the school climate committee remains unchanged, and the reporting requirements are there. We're simply adding the attendance review team. One other aspect of this that we're proposing, I'll tell you, is the attendance review team is required to be formed for any school system that has a chronic absenteeism rate of 10% or more. But there's one other additional layer of protection we need to provide for the children. If there is a school in particular, not the whole system, but a particular school, and its absenteeism rate is 15% or more, then there needs to be a attendance review team for that particular school. The school also defines local school system chronic absenteeism rate and the other details that you would expect there. You know, addressing chronic absenteeism is not just about improving attendance. It's about taking the essential step forward and breaking down the barriers that prevent our students from reaching their full potential. I think anything we can do to move the needle in the right direction is something we owe the children of this state. For far too long, chronic absenteeism has affected communities across this state. It's forced our students to miss out on critical moments. Some of them are being deprived of those opportunities which just might be those aha moments that children have in school that give them inspiration for some future success that they want to pursue. Senate Bill 123 takes the best approach forward because it combats the pressing issue of absenteeism and gives our students the resources they need, but the solutions are found at the local level. The fix for absenteeism in one area of our state may be very different than what the right fix would be in another area. So the truth is we need to come together and work across the aisle to successfully address this growing crisis of our students. The last thing I will tell you is this. I don't know that we've got a silver bullet figured out, and I think, quite frankly, we need to look at this in the long-term lens of trying to find a solution. It's for that reason I've asked for the formation of a study committee to meet this summer. We will continue to look at this and educate ourselves, and it is my hope by reinvigorating the school climate committees now, adding focus to it, and studying this over the summer, that maybe next year we might have some more refined legislation that we have reason to believe will truly address this issue in a way that will make a meaningful change. With that, Mr. President, I'm happy to answer any questions.
Do you have a question, Senator, or you want to speak on behalf of? Okay. No questions, Senator.
Thank you. I urge your support for this bill. Thank you.
Recognize the Senator from the floor.
Thank you, Mr. President, and thank you, Mr. Pro Tem, for bringing this bill. You know, colleagues, if they're not in class, they can't read. They can't learn to read. Very, very important. Let me read to you something I got a few minutes ago from a superintendent in my area. He said, there just has to be more accountability if we want students in school consistently. What we're doing now is not working. How well said. I want y'all to pay particular attention to this map, please. I want you to know when you go into the Department of Education website, you can look at this, and what you'll find out is this absenteeism is not by a particular race. It's across the board. This absenteeism is not by a particular gender. It's male and female across the board. This absenteeism is not about grade. The absentee in K through 12, kindergarten is about the same thing as absenteeism in 12th grade. If you look at this map real close, there's only one county in Georgia, and that's Wilkinson County, that is less than 10%, and it's 5.1. Maybe we ought to be reaching out to Wilkinson County and finding out, Pro Tem, what they're doing. I think that may help. We may need to involve them in some of the conversations. I'm not very proud of my county. You need to look at your county. My county, Bullitt County, is 22.6%. 1 in 5 kids are chronically absent in our county, Bullitt County. Evans County, my next door county of my district, is 26.1%. Candler County, which I'm very proud of, is actually the lowest in my district, is 13.3%. Effingham, which surprises me, is 13.5 because I thought theirs would have been less. Chatham County, with the senator from the second, is 27.9. Almost 1 in 3 students in Chatham County are chronically absent. And again, to define chronically absent, as the pro tem said, chronically absent is missing more than 10% of 180 days a year. That's 18 days. That's 3 weeks plus 3 days. I guarantee you, the senators in this room, if your child was absent, you would have the wherewithal to help them out, get caught up and all. But we're talking about the poor parents that don't have that or don't know how to do that. So we've got to address this situation. We keep talking about workforce development. If our children can't read and if they don't come to school, we can't find jobs for them, jobs. So, Mr. President, I yield a well, and thank you, Mr. Pro Tem, for bringing this to our attention. Thank you.
Thank you, Senator. Senator from the 38th, would you like to speak to the bill?
Thank you, Mr. President. Good afternoon, colleagues. I wanted to experience what it was like to speak for a bill, so I wanted to come down here to the well. I truly want to thank the President Pro Tem for bringing this bill. I sincerely believe that absenteeism is the next front that we're going to have to confront when it comes to our educational system. Martin Luther King Jr. said intelligence plus character. That is the goal of true education. And if our kids are not in our schools, they're not receiving that education. All of this hard work that we're doing, Mr. Chairman, on literacy is going to be for naught if our kids are not in school learning the science of reading. And so I was alarmed when the President Pro Tem came and spoke to our committee and shared that 20% of the kids in Fulton County are missing 3.5 weeks or more of school. We have a problem across the state that we have to address, and I look forward to working with you all to help solve this problem, because we have to get kids in our schools. And I truly believe addressing school climate committees and getting some folks to really pay attention to these issues is going to make a difference, and I look forward to the future work that we do. And Mr. President, I yield the well.
All right. Does any other senator wish to speak for or against the measure? Senator from the 18th, do you want to close? All right, good. All right. He waives. Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Is there objection to agreeing to the board or committee, which is favorable to the passage of the bill? Chair hears none. Report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 54, the nays are 0. This bill, having received requisite constitutional majority, is therefore passed. Who's stepping in for the majority leader? The Pro Tem. Recognize the Pro Tem for a motion.
Thank you, Mr. President. I move that the Senate stand adjourned until 10 a.m. until tomorrow, Thursday, February 27th, 2025.
The Pro Tem has moved. Secretary, read the announcements.
Mr. President, the Rules Committee will be upon adjournment in room 450 in the Capitol at 2. The Public Safety Committee meeting has been canceled. The Agriculture and Consumer Affairs Committee meeting has been canceled at 2:30 p.m. The Transportation Committee will meet in Mez 1 at 3:30. The State and Local Governmental Operations Committee will meet in the room 307 of CLOB at 4:30. The Finance Committee will meet in Mez 1 at 4:30. The Interstate Cooperation Committee will meet in 307 in the CLOB. At 5:30, the Health and Human Services Committee will meet in room 450 in the Capitol, and at 6:30, the Government Oversight Committee will meet in room 307 in the CLOB. That completes the order, Mr. President.
Senator from the 9th, would you have an announcement?
Thank you, Mr. President. Thank you, Mr. President. Georgia Legislative Black Caucus members, we do have a meeting today in room 310, CLOB, 3 o'clock. Thank you.
All right, any other announcements? Hearing none, the Pro Tem has moved the Senate stand adjourned until Thursday, 10 a.m., February 27th. All those in favor of the motion signify by saying aye. All those opposed, no. Ayes clearly have it. Have a good day.